been offered a contract to publish your board game, but there are loads of clauses in there about intellectual property rights, indemnity and liabilities. You're not a lawyer. It feels a bit like wading into a pool full of sharks. What are your responsibilities as a designer? And how can you protect yourself from claims and challenges from other parties? I'm Adam Porter. I'm a board game designer from Wales, and in this series of short videos I'm taking a look at licensing contracts between designers and publishers. If you're finding these game design videos helpful, please share them with other designers and don't forget to subscribe. I'll preface this video by clarifying once again that I'm not a lawyer. I have no expertise in contract law, but I've signed a dozen or so board game contracts and I've rejected a few more. So I've got a bit of a feel for what they tend to contain and things to look out for. That said, if you have any queries or concerns about a contract which has been proposed to you, please do get appropriate legal advice before signing. Don't blindly follow my advice. I've selected a few short passages from contracts which I've seen and I'm going to share them with you. In this video, I'm specifically focusing on your responsibilities as a designer. The author shall make available to the publisher all know-how relating to the product or the commercialization of the product. There are not an awful lot of responsibilities placed on a designer in most contracts. The clause about sharing information or know-how relating to your game concept is fairly obvious. How could the publisher proceed at all if you didn't share details of the game with them? The author shall keep confidential all aspects of this agreement until publication of the product. It's really tempting when you sign a contract with a publisher, especially if it's your first contract, to celebrate loudly, crying out the news to anyone who will listen on social media. Make sure you check with the publisher before you do this. Many contracts have confidentiality clauses, and your publisher may want to control the release of information about their upcoming products. In my experience, most commonly, publishers have been happy for me to talk about my upcoming game before its release. But on some occasions, publishers have asked me to hold off on discussing any details until they're ready to formally announce the game. In all cases, it's worth asking the publisher before you share any information. Some publishers, especially in the mass market, will go one step further and ask you to sign a non-disclosure agreement, an NDA. This is a broad document which covers all aspects of the company's business, requiring you to keep confidential all details of your conversations with them. Specifically, these documents seem designed to prevent information about their business strategy falling into the hands of their competitors. Larger publishers are also very cautious about looking at prototype games without paperwork in place to protect them against claims of copying that original work. They're often working in-house on multiple properties, and they don't want any superficial similarities to your prototype in their future releases to lead to claims from you of copyright infringement. If you want to learn about protection of game ideas, trademarks and copyright, click this link. The author represents and warrants that the game is an original work and does not infringe upon the copyrights, trademarks, patents or other intellectual property rights of any third party. This is a standard clause in all contracts, though it may be worded differently. Essentially, your responsibility as a designer is to declare that you haven't copied anybody else's work. It's a strange clause because my understanding of the law is that nobody can claim ownership of an idea. Copyright protects the written word, generally the written rules, and physical realization of a product, none of which is the responsibility of the game designer in most instances. The risk here seems very low indeed. How many non-licensed Monopoly clones are available on the market, uncontested by Hasbro? How many retitled rip-off editions of Connect 4 or Guess Who? The situation is exactly the same in the video game industry. There are an incredible number of battling go-kart games which closely resemble Mario Kart with different characters. Likewise for Super Smash Bros., Street Fighter 2, or any number of other intellectual properties. The author shall indemnify the publisher against any third-party claims at his or her own costs. Well, this is perhaps the most pertinent point. You're not just indemnifying the publisher against successful claims. Just because a claim is unlikely to be successful doesn't mean that a claim couldn't be made, and legal expenses could be high. There are big players in the tabletop industry who guard their intellectual property fiercely. Taking one of these industry giants on in the courts would be incredibly challenging and intimidating. This contract spells this point out. The author indemnifies and holds the publisher harmless from any request for payment, costs or compensation, including the costs of any procedures or fees paid as a settlement, to which the publisher might be exposed due to complaints or legal proceedings, whether or not they are justified. The contract requires the game designer to take responsibility for financial losses from any legal fees, even if the claim is entirely unjustified. Each party shall, at its own expense, carry appropriate insurance coverage of an amount adequate to support its liabilities under this agreement. This is a rare inclusion in a licensing contract, but perhaps a logical extension of what we've already discussed. If you're going to indemnify the publisher against legal claims, how are you going to fund it? This particular clause requires the designer to have insurance. So what sort of insurance would this be? In truth, I've never quite got to the bottom of this. I've asked a lot of board game designers in person and online, and very few have any sort of insurance at all. I've investigated with insurance brokers, but nobody has an off-the-shelf product for board game designers. As a result, you end up looking at a wide range of different policies, covering you for various eventualities at wildly variable prices, but you're totally in the dark about what's actually appropriate. I ended up approaching companies that insure novelists, because the publishing model for authors of books is very similar to the publishing model for authors of games. Ultimately, the insurance broker put together a professional liability product for me, which I think fulfills the requirements of the contract. But in truth, I'm not at all certain that the policy would fully protect me in the event of a claim. Sadly, there is no union to advise board game designers. There is SAS, a German association of board game designers, which invites members from around the world. They may be able to advise, but often we end up relying on conversations with our peers through online forums. I'm a member of several designer groups on Facebook, which are extremely helpful. The author and publisher agree not to work in their own name or authorize a third party to work with any product similar to the game that might be in direct competition to it by virtue of these terms and conditions. This is a very common clause and a rather ambiguous one. How close does a game have to be regarded as similar? And what constitutes direct competition? If you have one deck builder on the market, can you design another deck builder for a different publisher? Wouldn't those products be in direct competition? I think in such cases it's worth looking at precedents set by other designers and publishers in the industry. Uwe Rosenberg has designed many polyomino tile-laying games with several different publishers. Patchwork from Lookout Games was followed by Cottage Garden, Indian Summer and Spring Meadow from Edition Spielwiese, and then Feuerland produced New York Zoo. All of these games are demonstrably similar, all by the same designer and undoubtedly competing for the same market. It appears that they are not similar enough to constitute a contractual problem for Rosenberg or his collaborators. I guess the clause is largely there to prevent a designer licensing the same game to different publishers simultaneously under different titles with different presentation or only very minor rule changes. With regards to unrelated games that author might create or design, it is expressly agreed and understood that no preferential pact shall bind him or her to the publisher, and that he or she will be free to propose them to any publisher of his or her choice. Well, this really goes without saying and shouldn't need to be stated in a contract. Your license with that publisher relates to one game only and perhaps some derivative works from that concept, but it certainly doesn't limit your ability to work with other publishers. So I was surprised when the following clause crept into a contract that I was offered. The author commits to the publisher not to conclude with a third party a publishing contract for another game, before having proposed this game to the publisher in order to conclude a license on the same conditions. A breach of this clause will lead to a claim for damages. This was a very unusual inclusion, and I'm glad that I spotted it. A good lesson that designers should read their contracts extremely carefully and ideally run it past at least one other industry professional. If I had signed this contract, I would have agreed to give this publisher a right to first refusal before showing any of my future games to any other publisher. I requested that the clause should be removed from the contract. I've spent several years building very strong relationships with many publishers. I would not want to damage these relationships by giving priority to any particular publisher on future games. I believe that some games fit with some publishers more comfortably than they do with others. I want to retain the freedom to offer my games to the publisher that I feel is the most appropriate for the material. I also work in collaboration with other designers on various projects. This clause would impact on those games and those designers, limiting my options for collaboration. And companies sometimes approach me to design a specific type of game for them. I wouldn't be able to provide this service, since I would have to offer any such game to this publisher first. And finally, and probably most importantly, this clause gives the author no opportunity to move away from the publisher if they're unhappy with the work that's been done. If the initial project was not a satisfactory experience, the author is still tied to that publisher. Fortunately, the publisher was willing to remove the clause from the contract when I requested it. Contracts could stipulate other minor items. You might be required to attend a couple of trade fairs or conventions to demonstrate games or sign copies of your games, but these inclusions aren't all that common. That's not to say that publishers won't make demands on you once the game is in development, or even after publication. I've certainly been asked to do development on games after licensing them to the publisher, something I'm not contractually obliged to do, but within reason it's in my interest to do so. The alternative would be to refuse and let the publisher alter the rule set as they wished, which could lead to a product that I'm not happy with. However, it is a demand on your time, and it's not directly remunerated, so I would advise communicating clearly with the publisher about how much responsibility you're willing to take on for development work after signing a contract. Likewise for promotional work if requested by the publisher. Contractually, both development and marketing of the product are usually the publisher's responsibility. A publisher may, of course, approach you to develop an expansion, a sequel, or a new edition of your game. And if you want some tips on this scenario, click the link.